That's why you're excited about to answer the questions. Anyway, go ahead.
Thanks. Mr. Seltz, thank you for your very, very interesting and presentation, very clear presentation. I just have one question. From the time the proposed changes were, when the proposals came forward from the provider, how long did it take until a decision was reached by the court? What kind of span of time? I may have missed it. But.
Yeah, so this was quite a lengthy period of time. So the initial proposals were really at the beginning of 2013, and the final court judgment was at the end of 2014. So this was a 2-year period of time. Our work does have a time limit attached to it. And so while we are, like I said earlier, while we're conducting our reviews, they can't move forward with the transaction. But we have basically a backstop. So we can't, on our side, we can't investigate forever or review forever. That at a certain point, we are required to issue our report. And so our part of the process was a little bit more time delineated. The legal part of the process stretched out a little bit longer.
And I have one other question. During your investigation, you made a strong point of how this was extremely transparent and public. You meet in public, you discuss these issues in public. Did that raise any concerns on the part of the systems and how deep in the weeds you could go?
I would say yes, and I think it was a good thing. I think part of what makes this process work is that we are doing it in a way that is transparent and engaging and really bringing to light some uncomfortable conversations with some of the providers. And so we have 150 to 200 members of the public that attend every one of our meetings. We have members of the press that attend every one of our meetings. They're highly reported. And so in this case, we were certainly drawing more public awareness, and that may play out in both the press and in kind of general knowledge. And so I think for many organizations, they don't want to be on the front page of the Boston Globe around potential questions around their affordability and their plans for acquisition and consolidation. And so in that regard, I would agree with you. Yes, there's some uncomfortableness there, but I think a part of what made this process work.
Thank you very much.
I believe Senator Pan.
Thank you. Thank you very much, Seltz. I appreciate you being here. Actually, I came from Boston. I did my training there. In fact, I was in Boston time when Partners came together. It was right after a downsizing that happened in the general hospital sector at the time. That was in the 1990s with the movement managed care. Actually, California was way ahead. California was much more integrated. And in fact, I had worked with people like David Blumenthal and others there looking at academic health centers and consolidation and so forth while I was doing my fellowship in Boston at the time. In fact, I know some of the members personally. In fact, I was just in Boston in January, had some conversations with them about the Health Policy Commission and some of the things that were happening. In fact, I'm very familiar with this particular case because I know people both on the Health Policy Commission and at Partners and many of the other players as well. So I appreciate your presentation. So one of the things that we, of course, struggle with here, and actually maybe you can speak to, is that you talked about how your commission, as a state commission, did this in-depth analysis and so forth. So what kind of resources are you provided by the state, and who actually conducts this work? Is it, I know there's many academic health centers in Massachusetts. Is that something done directly by the commission? Do you contract that? Do you with some of the health policy folks over in Harvard or Tufts or Boston University or whatever? Can you speak a little bit about how that analysis is done and who funds it and so forth? And then so can you speak for that?
So the commission is generally funded by the industry itself. And so moving forward from this state, there was an initial kind of one-time deposit of funds that kind of was a startup fund for many of these activities. But moving forward, our annual budget is assessed to hospitals and health insurance companies on a broad-based basis. And it's spread broadly, such that that hasn't been an issue in terms of potential concerns around conflict. We, I think, recognize that in order for this work to have the impact that we wanted, it needed to be extremely rigorous and in many cases unimpeachable. And so we have built both some expert staff that we have internally, and the 30-day reviews that I mentioned are primarily conducted kind of internally with internal staff. When we do the longer reviews, we do contract with outside experts and consultants. There are some services that frankly, a state government agency cannot employ directly. And so we contract with some of the nation-leading economists, actuarial firms, modeling experts, and accountants that help us be able to do this analysis in a rigorous way, and then stand behind the work at the end, so that when we put this out publicly, it's not just a government agency saying this, but really many different firms with many different credentials behind it. But it is a resource-intensive process. And so therefore, when that full, more lengthy review is something that is very judiciously utilized. And so to date, over 3 years, we have only conducted 4 of those higher reviews. And so I'm happy to provide you kind of more specific information if you're looking for kind of budgetary numbers, but I did want to confirm, yes, it requires both staff and consultants.
Thank you.
I'm very impressed, and number one, I want to thank you for flying to California, and as I said, I'm very impressed with your Health Policy Commission and what the legislature found it necessary to bring forward and put into statute. And the last example you gave of how you're looking at this consolidation that essentially is going to increase the cost of health care to your constituents, and how you, along with the courts, prevented that. So this Health Policy Commission, what prompted the legislature and the governor to sign it? Was it to do this, but more in particular, was it because they were concerned of consolidations? Obviously, this was right around or after the Affordable Care Act. And so tell me what prompted this? And I have some other questions I want to follow up with you.
Sure. I think, one, we have been, I think, fortunate in Massachusetts that our Attorney General's office released an examination report basically dating back to 2010 that highlighted the differentials in price that I mentioned earlier as far as the big significant variation. And so in Massachusetts, we had a clear awareness that the market structure mattered in terms of what those prices were. And so when we thought about the healthcare cost containment aspect of this, we didn't want to just focus just on kind of how do we make the system more efficient, but the way that relationships come together can be impactful as well. I would say in some cases, this was foresight on behalf of the legislature. I think really right around the time that we passed this law was when we have seen this dramatic increase. And I think, the environment now is even more clear how important it is to examine and look at provider consolidations. And so I think the political process was a long one that led to this bill. Dr. Ginsburg mentioned, rate setting and more intensive, shall I say, government interventions. Those were things that were discussed at the time. Ultimately, the law still takes a market-based approach. And so this is not direct government regulation of these institutions and is really trying to provide transparency and examination to make the market work better. And so that was ultimately where we landed on that, and I think ultimately found that going a more regulatory route was not prudent at that particular time.
Okay, and I understand that it's been in existence for a very short period of time, but during that period of time, have you seen evidence to show that, with example, the last one, that you've been able to at least maintain or control costs better compared to previous decades or years?
So our overall statewide experience has been mixed during this time. In the first year, we met our overall statewide benchmark of growth. Our target is 3.6%. In the first year of examination, we came in at 2.3%. The second year of examination, we found that healthcare spending grew at 4.8%, so higher than our 3.6% target. Upon examination, we found that the primary driver there was actually pharmaceutical drugs, and the prices for pharmaceutical spending was a major component of the overall spending growth during that time, as well as enrollment in Medicaid due to the Affordable Care Act. Specifically to this process, and I guess I will speak more anecdotally than anything, I think what this has provided is, for a long time, providers thought of these new relationships as business relationships only, and how they could be strengthened financially by seeking out and finding those new partners. What this process allows for is we are asking questions on what is the benefit to society? What is the benefit to the whole state from you guys coming together? And what we've seen, and I would admit this is anecdotal, is when we've conducted some of these later reviews more recently, and we're able to get information about the kind of the development of these deals, explicit in the materials is their own consideration of what is the Health Policy Commission going to think of this deal. And are there ways that we can structure different parts of this to ensure that we have a really, really strong case to bring before the Health Policy Commission in having something that is going to really provide a positive impact? So even asking the questions and having some sunlight has changed the way that provider organizations are structuring these deals from the outset. Dr. Ginsburg mentioned something earlier around not all consolidation is the same. And so, you know, we're talking here, and in this case, this was a corporate consolidation. And in some cases, what we've seen in Massachusetts is providers are now pursuing not corporate consolidation, but just contracting together, maintaining independent status, but contracting together in order to be able to do risk-based contracts or to do payment reform, but not having the full corporate consolidation. And so I think our results, our examinations have found that asking these questions have led to changes in the way providers have approached and thought about how best to meet their future needs. And look forward to reporting back with more results in the future.
And you had mentioned that, you know, the Health Policy Commission does not have the ability to block or deny, but in collaboration with the Attorney General, you've been able to at least have a public forum so that it can be brought to the courts. Do you believe, in retrospect, obviously you're not a policymaker, do you think it would be better to have the ability to block and deny so that it can be done something much quicker at all? Just your opinion.
I would say it's an important consideration for this committee. I perhaps will dodge respectfully the question. I think to date we have found our process to work, but the way that it has worked is because the providers who are coming before us respect the authority of the commission, and in some cases have said, how can we make this deal work for you and for the citizens of the Commonwealth? One can imagine a scenario where provider organizations don't necessarily aren't that receptive to kind of public scrutiny or for government raising concerns, and may decide to move forward even if many concerns were raised and public public opinion was against them. We have not had that experience to date.
Okay. One last question. We're always doing hearings on cost containment, controlling costs. One of the ones is obviously on high cost drugs. You had mentioned high cost drugs. What is the Health Policy Commission, what have they done and what are they doing with recommendations about high-cost drugs, and how do you control that?
So one of our broad mandates is to examine our performance underneath our goals every single year. We produce an annual cost trends report, which really dives deep into what are some of those underlying trends. All of these reports are on our website. Encourage you and others to check them out. We noted that in 2013 to 2014, the largest category of growth was prescription drugs. And this included both the new hepatitis C vaccine drugs that came on the market, but also included price increases for generics and price increases for brand name drugs that had already been on the market. And so we have a broad mandate to be able to provide policy recommendations to the state legislature. In this particular circumstance, based on that evidence, we believe that further transparency about the pricing of prescription drugs, how those prices are set, the rebates and discounts attached to prescription drugs is within the public interest, and recommended that to the legislature. We don't have the direct ability to price set or to mandate certain price caps or in that way, but this was an area of focus and interest, and did have a set of recommendations for our legislature to consider.
Okay, and because of the transparency and looking at the trends and the cost, you had mentioned obviously the Hep C, has the legislature acted at all, or has it led to any kind of reduction in cost of prescription drugs?
The legislature has not acted to date. I would say that there is a robust dialogue in Massachusetts around the impact of pharmaceutical spending. As this committee knows, Massachusetts, along with California, is often held up as one of those life sciences, pharmaceutical, bio-innovative states. And so we have a very robust constituency with very specific perspectives on this. There is a bill that is pending before the legislature that would actually give the Health Policy Commission the ability to set prices on specific high-cost drugs. That bill has not been passed by either branch to date.
So one final question. This is the most important one. Who's better, the Boston Celtics or the Los Angeles Lakers?
I'm actually originally from Minnesota, so I'm going to go with the Timberwolves. A very convenient dodge for me.
Because there's that big Laker, Larry Bird, Magic Johnson rivalry, the whole bit, going way back. Thank you very much. I appreciate your time. It was a great presentation.
Thank you, and thank you to the committee. Thank you.
All right. So we're going to now move on to, let me get my item number 4, existing agencies, authorities. We're going to bring everyone up. We're going to have Robert Sumner, Special Counsel for Legislation, and Kathleen Foote, Senior Assistant Attorney General, Antitrust Section, Department of Justice. I think we should have enough room for Shelley Roulard, Director, Department of Managed Healthcare, Janice Rocco, Deputy Commissioner, Health Policy and Reform, Department of Insurance. Thank you, welcome, and we'll go in order, if you don't mind, starting off with the AG's office, and welcome, and good afternoon, and thank you.
Yes, good afternoon, Chair Hernandez and members of the committee. Thank you very much for having me here today. My name is Robert Sumner. I'm here on behalf of the Attorney General. I want to start by saying I'm now incredibly self-conscious that I did not bring a PowerPoint, but I'm hoping I can, and I hope you can all visualize what I talk about today. I'm very grateful that we're doing an informational hearing on this issue, because I think it's a very complex matter that the Attorney General is certainly very interested in, and I think that there's a really good set of panels today. I want to specifically say that as far as Professor Ginsburg's comments, I think that there's a lot in there that the Attorney General's office would be quick to concur with, and I think it was very interesting to hear more about what they're doing in Massachusetts. I'm here today on behalf of the Attorney General in light of the fact that we actually have a number of different sections and divisions within the Attorney General's office that have potential nexuses with the issue that we're discussing today. Obviously, one of them is our charitable trust section, and I'll go into the work that they do in regards to specific reviews of a nonprofit health facility transactions. And on top of that, our Bureau of Medi-Cal Fraud is obviously very interested in these types of issues, as is our consumer law section, which handles a whole scope of consumer protection initiatives. And then particularly on this issue is, of course, our antitrust section. And so with me today is Kathleen Foote, who is the Senior Assistant Attorney General for that section. I will be going over kind of a general overview of what the Attorney General's role in these types of issues is. But for any particular questions about the antitrust concerns from the Attorney General's perspective, I'll turn over those questions to Ms. Foote, who can also be sure to be attentive to any sort of pending litigation sensitivities. So in light of that, there are, a couple of different ways to approach this. I'll go ahead and start, because I know that one of the only real analogous regulatory roles played by the Attorney General in this realm is our nonprofit hospital transaction review process. This is something that's handled through our charitable trust section. This is something that is invoked whenever you have the sale of, or transfer of assets that belong to the public through a charitable donation. So a hospital that is being sold, or a change in governance, a merger, any other thing, any other process that would kind of affect the future of those assets as dedicated for public benefit is reviewed by the Attorney General's office, and we actually have the ability to either approve with conditions, or deny a health facility transaction, and there have been several noteworthy instances of that in the recent past. This is a fairly limited subset of mergers and acquisitions in the healthcare industry. It doesn't apply to acquisitions of physician groups or clinics or other outpatient facilities, and obviously it doesn't apply to hospitals that do not have nonprofit origins. But when we do conduct a review of these types of transactions, we do something somewhat analogous to what was described by the Massachusetts representative, which is we do a full public impact study into what the predicted impact on access to care in the community would look like, which involves a number of different factors, but obviously the potential market consolidation or antitrust concerns factor is something that we do take into consideration. And in that letter, charitable trust section works with Ms. Foot's section and make sure that there's a thorough antitrust review for possible market interference or anti-competitive impact. In terms of what we're able to do affirmatively through litigation and through the work of the antitrust section, we work within a certain judicial landscape that evaluates market concentration and the dangers of market power in the healthcare arena for specifically hospital mergers, using kind of a recent set of decisions, which I think Professor Ginsberg actually alluded to earlier, that kind of replaced a more unfavorable, outdated economic model that we'd been previously forced into using, but has now been largely discredited. The more contemporary approach factors in the market forces that pertain to the world of employer-based health insurance, with a number of studies showing that insurers putting together networks of providers for employers end up paying more when providers merge and thereby get increased price leverage. So this approach has now begun to work its way into our case law. Actually, last year, the Attorney General co-authored a multi-state amicus brief in the Ninth Circuit to support this model and this economic thinking. And this has been used by the FTC to assess the market impact of specifically, as I believe Professor Ginsberg referenced, the St. Luke's Hospital Seltzer Clinic merger, which took place in Ohio. So the Ninth Court's decision actually accepted this new approach by the FTC and affirmed that the lower court's rejection of the merger should be sustained. The reason why this decision was so important for us is because it allows the Attorney General to fit empirical observations regarding the role of employer-based health insurance into an analytical framework that more accurately gauges the price effects and competitive harm of future transactions. It is useful in understanding not just the impacts of hospital mergers with other hospitals, but also the current wave of consolidations of hospitals with clinics and hospitals with physician groups. These purchases of physician groups and clinics by hospitals carry with them the potential for amassing of market power sufficient to drive prices up. And that happens in at least two different ways. The first way that happens is technology allows many medical procedures that were formerly necessarily hospital-based to be done instead by clinics or just in a doctor's office. So nowadays, a merger that consolidates these different types of institutions could eliminate some or all of that competition among them as to those particular procedures. Those types of procedures could include ambulatory surgery, it could include dialysis, in some instances it could even include chemotherapy. For the St. Luke's merger case in Idaho, it involved a hospital clinic merger, and the reductions in the competition were this type were kind of the crux of the FTC's successful case. Our office is currently conducting a confidential investigation that presents similar issues. Secondly, common ownership of these entities can lead to the exclusion of competitors over time through the practical realities of patient referrals by doctors to hospitals, by hospitals to clinics, or other outpatient specialty services, and so on. The competitive effects of referrals within consolidated healthcare systems have not yet been completely scrutinized by the courts, so they have not yet been fully studied by the antitrust enforcement community, but our office is definitely not alone in having grave concerns about these types of events. Then in terms of the work that the antitrust section is able to do in regards to anti-competitive conduct, our antitrust section can investigate and litigate this type of conduct either through state antitrust laws or federal antitrust law. The federal law is obviously our primary instrument for monopolization or other unilateral conduct by just one party. But as was previously mentioned, California's Cartwright Act gives the Attorney General a broad authority to take legal action against bilateral anti-competitive behavior, such as price fixing or market allocation agreements among competing businesses. So, including the Cartwright Act, because it's focused on bilateral action, an agreement, a contract, or a conspiracy, this can also embrace contractual relationships between dissimilar actors, such as a hospital and a health plan or physicians and clinics. So contractual arrangements between providers and health plans that foreclose competition in either the provider market or the insurance market could be reachable under either state law or federal law. But this is a fairly new arena for antitrust enforcement to be operating in, and so we're not operating with a significant amount of legal precedent to pave our course in that area. Within the last 3 years, our antitrust section has done a number of investigations that have confirmed that, similarly to the Idaho case, the demand by patients for provider networks that are located closer to where they live increases the competitive pressures on employers and commercial insurance companies to offer the same, amplifying the bargaining leverage of large healthcare systems and reducing effective price competition. We now have the benefit of a few recent court decisions, including the St. Luke's case, which recognize that competitive effects need to be seen in the context of provider-payer relationships and the need for insurers to put together attractive networks of providers for employers. Healthcare purchasing can essentially be broken down into 2 different stages. The first stage is the negotiation on price and other terms between insurers and providers when insurers are trying to put together attractive networks that they can market to employers who need providers close to their employees' homes. Once employers purchase or rent those networks, the second stage that we see is the use of these networks by employees, which determines not the price, but the volume of business that each provider gets. So when the first stage occurs, that's where the negotiations on price take place. The actual selection of a provider in the second stage is not based on price, but on other factors such as, convenience or referrals. Because of the first stage and, also just the need to put together a viable network of available options, that's where there's really a critical step where prices get negotiated and a dominant provider could be able to exercise its market power within a narrower geographic area or with a lower market share than has traditionally been recognized as sufficient to gain a price premium. Sufficient market power, and this was something that I believe that was previously mentioned by the professor, sufficient market power can also allow for a dominant provider to insist upon the inclusion of some contracts with health insurers with certain anti-steering or anti-tiering provisions. These are provisions where we see a little more rarity. They're really the exception rather than the rule, and in our experience, this is something that is strongly disfavored by health insurers. In declining to block a hospital merger previously, at least one court has pointed to the ability of health insurers to steer their insureds to lower cost, higher value providers, and this offsets the possible loss of competition occasioned by the merger. And indeed, when offered a financial incentive to comply with such steering advice or to choose a lower cost, narrow network tier, our office has reason to believe that certain insureds may do so. There certainly can be competitive benefit in this, assuming the practical availability of lower cost options within a given business volume. But that in turn arguably serves to encourage all providers to improve their efficiency and improve their prices the next time that they negotiate. Contract terms that prohibit steering or tiering can be viewed as eliminating this potential competitive benefit. And this could be harmful to overall healthcare market competition when they're made when they're forced to have these as requirements of doing business with a certain dominant provider. So when anti-tiering and anti-steering agreements are present in insurer relationships with providers, opportunities for price comparison shopping get significantly reduced. This can lead to what some have referred to as the cartelization of the market, where recent state legislation has mandated disclosure to patients of the estimated costs of anticipated medical procedures. There's a hope that this will inject competitiveness into patient choices of providers that might mitigate the effects of anti-steering or anti-tiering provisions. But this sort of transparency may not prove to be as effective as hoped, where there's one dominant provider that's involved in the transaction. What we can kind of say as far as Obviously, we don't have any specific recommendations on any of these issues, but what we can say is probably one of the most important things for policymakers to look at when studying this issue is really the impact of these provisions on the cost of healthcare and how those can vary considerably from region to region. The Attorney General has been looking into those sorts of issues specifically with a number of investigations. What we can say at this point is that there are studies that have begun to tease out a correlation with higher provider concentration and higher prices in certain regions that are covered by the Covered California Exchange. The antitrust section staff has also studied the steps Massachusetts has taken in regards to contracting practices. And where the impact is significant, our view is that it's probably going to take, an all-of-the-above approach with regulation, litigation, and potentially state legislation to lead to an effective monitoring system for these provisions. And then I'm able to speak actually a little bit to pharmaceutical pricing as well, because I think that was something that Chair Hernandez expressed interest in. The Attorney General's office has actually for the last decade been very interested in this issue. We've joined with other states along with the Federal Trade Commission and a number of private litigants in challenging reverse payment settlements, which are also known as pay-for-delay agreements that are initiated by pharmaceutical companies. Our office actually authored and co-authored a number of amicus briefs on the subject, and we expect to continue to work on this area because we believe that the effects of such agreements on the public and the state itself can be very severe. I can have Kathleen speak more to that if there are questions, but that is, I just want to flag another very significant area of interest for the Attorney General.
Thank you. Go ahead, please proceed.
I don't have anything specific to add to what Mr. Sumner has said. We have, on the pharmaceutical end, for about the last 10 years, we have joined in with, I think, probably about at least half a dozen pieces of litigation that have, by and large, brought back to California either money and damages sustained by state agencies, and also civil penalties under our unfair competition law. It's an extremely difficult area. It is, and it's difficult to have an impact across the board because it proceeds on a drug-by-drug basis. Each drug is its own market, essentially, and involves its own agreement between a generic and a manufacturer. A name brand manufacturer. So it is extremely slow going. To the extent that there are federal laws in place regarding patents, regarding early entry of generics and so on, those certainly do play a role in many of those cases. There's there is a kind of a gaming of many of those rules by the companies involved, and either taking advantage of specific loopholes that exist or taking advantages of the time lags that arise, and that is something that. Unless there are changes at the federal level, there's not a lot that at least we in the Attorney General's office feel can be done short of the kinds of litigation that we and some other states have begun to bring, generally along with others. California itself has, the California Supreme Court has recently opened the door to handling some of these under California law, under the Cartwright Act. A very important case last year was decided by a unanimous California Supreme Court, adopting largely the same kinds of standards that the U.S. Supreme Court had adopted for these cases. It's too early to say exactly where that new open door is going to lead to. Certainly, it's something that our office, because our office is very particularly charged with the Cartwright Act, is looking at very carefully and with great interest.
Thank you very much. We're going to go ahead and move on now to our third presenter. If we can have